morning, everyone.
Good
Good
morning.
morning.
So we are here with,
May, and this is the legal play.
yes, and we are here again with Anna Lee May, our guest speaker on all things probate and intestate succession and all of those related items. Today, Anna Lee, we are talking about intestate succession and what happens when you don't have a will.
Yes.
It's a perilous situation if you don't have a will. So I suggest you get one. But just in case you want information as to what happens when you don't have a will, we will discuss that today.
And we did a podcast, you and I, about wills and powers of attorney and why it's definitely good to have one. And we hinted at, as you said, the perils of not having one. So we are going to talk today if you are dealing with the death of a loved one who has not left a will, what happens?
Well, it's not exactly as you would think. I've been asked several times, well, if there's no will, doesn't my spouse take everything? No, the short answer is no, and it gets more complicated from there. But we can talk about the different areas, and there is a pie chart in Texas that sets out everything that you need to know about intestate succession. But we can start with your personal property. If you're married and you have children or other descendants, 1/3 of your personal property will go to your surviving spouse. And then your children will take the other 2/3 equally.
Now, when you say personal property, does that include the house, like real property?
No, personal property is not the house. Would you said real property? That's the different category.
Okay.
We've got real property and personal property.
So personal property would be like the car,
a boat, jewelry.
bank account?
No, we discussed bank accounts. Bank accounts will pass outside of, oh, well, here we are.
I mean, generally the pass outside, if in fact there are joint accounts with rights of survivorship, the way most bank accounts are, because husband and wife are co-signatories. However, though, if you have a case where it is just the decedent is the only signator on the account, then it does have to pass through the probate process, and it would count as in the personal property category.
Of intestate succession.
Yeah, intestate
Okay.
succession. And I know that we use that word a lot. You know, basically that's a big fancy word saying you ain't got a will.
Right. Intestate means you die without a will. I feel like we should have started with that. People are intestate, what? Yes, but so like our bank accounts and things like that, cash, that's personal property. And what you're saying, Annalie, is if you die without a will and you have a spouse and children, that your spouse would get 1/3 of all of that?
Correct. And then the children would take equally from the remaining 2/3.
How does community property come into play in that? If we're in Texas, and a lot of people who are married in Texas may even understand, well, okay, my spouse, has rights to everything that's community property. Does that change in this case?
It's interesting that you asked that, because in terms of a home, people usually are concerned about being kicked out of their home. In Texas, although you only would get half of, you would get your share and then a portion of your spouse's share. In Texas, you do not get kicked out of your home. You can live in it your entire life.
And you, in that case, is the surviving spouse.
The surviving spouse. Yes. And then the children, the surviving spouse would get 1/3 life estate in the decedent, the spouse that died, personal property. Then the children would take equally, subject to the surviving spouse's 1/3 life estate. Life estate meaning you get to stay in your home for your life.
Can you make improvements or changes on the house, or would the children have a say in that because they have an interest in the house? This is fresh out of law school.
Yeah,
brain.
no.
I understand that. And the general answer to that is, I mean, they can make improvements to the house. They can't waste the property. Meaning they can't junk the property up. They can't tear down, part of the structure. They can't do damage to the property.
If you
But
have
they certainly can maintain it.
if you have
And
tenants and renters come in, let's say you've got a big house, I mean, would your kids be able to come along and say, we get a third of that?
Well, you're talking about renters. We're talking about someone that's able
Right.
to stay in the home throughout their life.
Right.
If they move out, then all of this goes by the wayside. Okay.
Right, they lose it's a special kind of home, it's a homestead right.
Got it.
That only lasts for their life.
Okay.
Or until they've had a problem.
Okay.
And one thing we haven't mentioned yet is even though you die intestate, and there's this statute that says how everything's gonna be divided up amongst your spouse and children, and we'll get to what happens when you don't have a spouse and children. But there is still a judicial process that has to take place in those cases. Where you have to actually open up probate and get the court to appoint an administrator in most cases.
Right. And if you have a will, you can actually name the executor and it could be your spouse. And in that case, because Annalee, we're talking last time about the wills, that it's much easier to bring this official piece of paper that's been signed off on saying, I want this person to be the executor of my estate. The judge can say, okay. But if there's no will, then there's a whole process of trying to find an executor or an administrator of the estate.
And it's still under the umbrella of probate, but you're going to the court in this instance asking for an independent administration rather, and that's with people that are interested in the estate, but that they were not, designated in a will as the executor.
And in some cases, you could get an administrator. Basically, all of the heirs are kind of agree to it. But in cases where they're not, you can't get an agreement of the heirs. You would have a dependent administrator, which means basically everything that has to happen of any significance has to be approved by the court. You have to have lawyers that file motions, go to have hearings, argue over whether a house should be sold at this price or whether the oldest son should get the car. I mean, all of those litigated.
And that assumes, though, that you have a spouse and maybe a handful of children that generally can agree. I think that would be like the best case scenario.
Yes.
But we do have some clients come in who aren't married or, their spouse has predeceased them and they had no children. What happens in that case if there's no will?
Well, in that case, the decedent's separate personal property will go 100% to the surviving spouse. And then when it comes to real property, it gets a little more complicated. And I'm going to consult my chart here where it says if a decedent is survived by both mother and father, 1/4 would go to the father, 1/4 to the mother, and half to the surviving spouse. This is real property.
Mm-hmm.
So, and then if a decedent is survived by the mother or father and by siblings, brothers and sisters, or their descendants, then the surviving parent would get a fourth to the siblings, and half to the surviving spouse. And we can continue to go through the
and
chart.
if there is no surviving spouse and no children, this is where it gets interesting. This is where genealogy comes in. Yes, go ahead.
So if a decedent is survived by neither parent, but is survived by siblings or their descendants, then half go to the siblings and half to the surviving spouse. If the decedent is survived by no parent, no sibling, and no descendants of a sibling, all go to the surviving spouse.
If there is no surviving spouse.
Yeah, what happens if there's no surviving spouse?
No surviving spouse, no children.
Then we have to find heirs. And we go to
We go first to the parents. And you kind of divide what they call mom, moiety, and dad in the process. And a lot of times they're deceased too. If somebody dies single in their 70s, probably doesn't have parents that are alive. So then you look at, okay, mom had children, dad had other children, basically siblings. But in that case, and sometimes it's with half brothers or steps instead of steps and things like that. But mom's then surviving children or grandchildren would take from mom's half, the dad would take from dad's half. We have had a few cases, and we have genealogists on staff here, that in cases where a 90-year-old man died without children, his parents died, in one case without children. We have to go back into the 1840s and go up to great grandparents and trace it back down and find 58 heirs or so. And there's a court process to do that. And then we've had a half a dozen cases that involve. So that's there. So even though somebody says, "Well, I don't, have any children, and my parents are long gone, why do I need a will?" Well, because you're going to find, fourth cousins that are, 58 fourth cousins that are going to divide up your estate. Maybe that makes a difference to you, maybe it doesn't.
This came up in a conversation with you and I last week, though, where we were talking about wills versus intestate succession, and in Texas, how it's done versus other states. Because in some states, you only go, I think, down the line twice. Okay, do you have surviving siblings? No. Do they have any kids? No. Are your parents alive? There's kind of this that you only go so far before
Right. In some states,
to the state.
yes, basically the state gets you money.
The state then gets the money, which is kind of this default thing. Okay, well, we went as far as we comfortably felt going. We couldn't find anybody, so now all of your assets then go to the state for the state to use.
Well, basically, it would go no further than a cousin, or in some cases, a second cousin. In some states with regard to that. Otherwise, it will go to the state.
And I assumed that was the same in Texas, but you corrected me and said, nope, Texas will find an heir. And my question was, well, okay, somebody's got to do that. Somebody's got to do the work to find that heir.
Yes, but I mean, there are these heir finders, which I don't particularly like, because they take cases, they get commissions where they're really not entitled to it. But nonetheless, there are people that do that go find heirs, and they'll call somebody up and says, your 12th cousin, recently died, and going to go figure, you have rights. And this happens a lot in Texas in particular. You get oil and gas lobbies, because some great grandfather, kind of stole a wagon in Texas and set up that bought a ranch, and then 100 years later they find oil under it, and then they have to find all the heirs that have entitlement to that oil. So you see a lot of that in heir finders. So there are people out there that do that. And obviously you have to have something in order to give. So a lot of people that don't have much of an estate, it doesn't have it. And there are cases where if there's a bank account that somebody dies, nobody sets up an estate, that after I think it's 7 years, the money doesn't sheet to the state. But then the heirs then at any point in time in the future can come to the state and prove they are heirs and be entitled to money.
Right. We do that stuff, though.
We do that.
Saying there are people that do.
We do that, yes.
Does heirship and genealogy and
right.
Deals with this.
Right. In fact, some of our more enjoyable projects.
Annalee has become very familiar with some of these cases and clients.
Yes, I have. In fact, I have one that's just a kind of an interesting case where it was a second marriage and the parents died, no wills, and one home and children on each side, but the house was in disrepair. It owed homeowners taxes, federal government taxes, and trying to keep the house from being foreclosed on. This is the road we had to take. So it's been very interesting.
Yeah, there's all kinds of complicated. I think every situation is slightly different. We've got one man, his wife died recently, and her mom's estate was going through probate up in Kentucky.
Yes.
And so there's some across state lines having to deal with
right.
two.
And there's just a very little bit of this, but we have to set up an estate so that this gentleman can get money from his wife's mother's estate in Kentucky, but in Texas, and we have to go through an administration.
So
yeah, and you mentioned something there, second marriage, which is kind of a red flag in the probate business, because probate attorneys fund their retirement and their college education based upon battles representing either children from first marriage or the second spouse. And if you are in that situation, you need a will. Because there, particularly if you have some, perhaps have any property with fighting, because it gets even people that seem to get along
Yes.
while dad or stepdad's
Yes.
alive. I mean, after that person dies, and then there's money to fight over. It can become really, really.
I think that's a good point to make, Hap, because recently I did a settlement agreement for a couple of clients that it went back to the fact that the mom died without a will, and the property was going to go to her two children. But then within like 2 months of that, the son then died,
Yes.
and the wife had some
The son's wife, yeah.
Right, the son's wife had interest in the son's portion of property, and so there was this, there was no will, and so they had to go through, private channels to agree, and a process for distributing up everything. And within all of that, like you said, two very lovely people who I'm sure got along while everyone was alive and well, suddenly it's just,
Yeah.
and but there's emotions involved. It's just really hard to deal with loss, and then at the same time, just be logical and try to get what you think is going to make you comfortable and feel like you got.
You said the key word, emotion, because so many times the emotion gets the better of us in these situations. That is what really makes it challenging.
And I think that's where we come into play to kind of try to calm the waters and make the process a little bit smoother so that there's not as much frustration and confusion trying to deal with the legal process when you're already dealing with a lot emotionally.
So the takeaways today are: if you're still alive, get a will.
And if
we have somebody die who's not, come on in and see us, and we'll figure out how to get it done.
yes. All right.
This is Hap May with a Legal Play.
Thank you all. Thank you.